This video provides general information about the process involved in obtaining a protection order in Trinidad and Tobago at this point in time. It is in no way intended to constitute legal advice. In order for a protection order to be granted in your favor, you, the victim, or one of the persons listed under Section 4 of the Domestic Violence Act will need to make an application. Since the amendment of the Act in 2020, the process has been made simpler and takes less time. Following this application, your abuser will be summoned to a court hearing to respond to and/or defend your allegations brought against him or her, where the court finds, based on evidence, that the abuser has or has more likely than not subjected you to domestic abuse and will continue to do so if not restrained, a protection order or any other order provided for under the Act will be granted. Due to the COVID-19 pandemic, physical access to court buildings has been restricted. However, domestic violence matters has been deemed urgent, and as such, applications for protection orders and related domestic violence matters are being heard virtually until further notice. So, how do you make an application for a protection order? In order to make the application, you will need to have a valid form of identification for yourself, a telephone contact, and an email. You will also need to know the proper name and the last known address for the abuser, who will be called the respondent in the application. You must know the specific date or range of dates of the incidents or omissions amounting to domestic violence occurred, and be able to recount in chronological order exactly what happened. You must also provide evidence of the abuse. The evidence must be believable and credible, and these may include receipts of all police reports made of domestic violence incidents, completed police medical forms you received when making reports of domestic violence incidents where you sustained injuries, previous protection orders or other orders if applicable, pictures, WhatsApp or other social media messages, screenshots, call logs, voice notes, videos, bank or other financial institutions' statements, etc. For applications for protection orders where there were allegations of physical abuse, medical evidence is required to prove this at court. Making an application. Where and how? There are now more ways in which an application for a protection order can be made. The application is made to the registrars of the Magistrates Court in your district or to the nearest Family Court Division of the High Court. During the pandemic, applications are being filed online by one of the following means. You may visit the Magistrates Court in your district or the closest family court in person, where a customer service representative will take your relevant information and forward to the court's registrar, who will then contact you to verify the information, following which they will file on your behalf. Since April 2020, you may call the Domestic Violence Hotline at 866-DVCT, that is 3828, toll free. Or you may also send an email to domesticviolence.response@ttlawcourts.org. They will record your information and forward to the relevant court registrars, who will then contact you to verify the details, following which they will file the application on your behalf. If you cannot afford an attorney at law, then he or she will fill out and electronically file the application on your behalf. If you cannot afford the services of an attorney and your matter is a complicated one, you may contact the Legal Aid and Advisory Authority in your district at 625-0454 or by email info@laa.gov.tt, and should you qualify for assistance, they will appoint an attorney at law to assist you. What happens after the filing of an application? The Act enables the court to schedule a date of hearing within 7 days of the filing of an application. A copy of the application for the protection order, together with a notice of proceedings advising of the date, time, and place at which the hearing of the application is to be heard, will be served on the respondent personally by a police officer from the police station nearest the respondent's residence or whomsoever the court may elect. This serves as a summons compelling him or her to attend court to answer or defend the claims being made by the applicant. The link to all court hearings will be sent to the parties' email or phone contacts. Where parties have no access to an email or phone contact, he or she may make an appointment to use facilities now available at the recently established virtual access customer centers as appears on the screen. The hearing. The hearing is a private affair, and only parties to the case will be allowed in the courtroom unless the judicial officer gives permission for an officer of the Gender-Based Violence Unit or a relative to accompany the applicant as a means of support depending on the circumstances. Should the respondent defend the allegations made against him, the matter will proceed to trial and you will have to return to court. The court, at the very beginning or at any time before the trial, may accept an undertaking from the respondent that he or she will not engage in the conduct specified in the application after the taking of evidence. The court will then grant the protection order at that hearing for a period of time at the judge's discretion, but not for more than 3 years. The trial. At the trial, you will be asked to identify the respondent and say how you are able to identify the evidence that you have provided to the court in support of your claims. The respondent will also be given a chance to defend your claims, and he or she may employ an attorney at law to act on his or her behalf. Upon hearing both sides and considering the evidence, the magistrate, master, or judge may then grant the protection order and/or other orders under the Act as deemed fit in the given circumstances.